Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. Welcome to the Meaningful Mediation Podcast. This is the show where we sit down with some of the best legal minds to talk negotiation, mediation, and the art of getting deals done. I'm your host, Patrick, and today I have a genuinely fascinating guest. Emanuel Galimidi is a Miami-based personal injury attorney who spent nearly 2 decades on the defense side, representing some of the world's largest insurance companies and corporations. Then he made a bold move. He crossed the aisle to fight for the people on the other side of those very same cases. Emanuel, welcome to the Meaningful Mediation Podcast. It's great to have you here.
No, thank you so much, Patrick, for the opportunity. I really appreciate it. Been looking forward to it.
All right. Let's start off with the fact that you spent close to 20 years defending major corporations and insurance companies.
Yes.
What did that world look like, and what kinds of cases were you actually working on?
The world it's a layered world, I guess, is maybe the best way to put it. There's lots of layers to it, internally at a defense firm, and then when you're dealing with insurance companies, as I know you've got your field level adjuster up until your VP, your president of claims. So I would say in a word, it's layered. And the types of cases were at the beginning pretty run of the mill, slip and falls, kind of graduated up the chain, if you will, to premises, more significant premises cases like negligent security, sexual assault. I did a lot of maritime work for a while, and then just before I left, we was doing a fair amount of product liability work. So kind of moved up the food chain, if you will.
And I'd be remiss without saying that we actually worked at the same firm back in the day.
We did.
Good and you run our reunion, so it's nice to see everybody once in a while.
Yeah, it's fun.
So at some point, you made
Yes.
the decision to leave and start your own firm on the plaintiff side. What drove you to that decision?
Two things. One kind of practical and one completely impractical, but it made sense to me. I'll begin with the second one first. In a word, resentment. Not resenting clients or the firm. I still have lots of friends there and a lot of really good people, a lot of great lawyers. But I was beginning to resent myself a little bit because I felt that I could do something different, a new challenge, and I felt that I should. If I could, then I should. And the other kind of creeping thought in my mind was, okay, if I'm feeling this way now, things are going well. I have a great team. I love the staff that I'm with. I've got a ton of autonomy. If I'm feeling this way now, and things like in any, career or any time you're anywhere, there are ups and downs, and then things take a turn for maybe not the worst, but just not as well as I'm doing now. How am I going to feel then? A lot worse. So in my mind, I'm like, this is only going to multiply if I just let it fester. But as you can imagine, it wasn't as easy as, let's say you and I, instead of having worked at Lidecker, let's say we worked at Rubenstein or Morgan & Morgan or a big shop where, okay, I leave and I have my 63 cases or whatever it is that I can kind of take with me and continue on, hire somebody and begin from there. A little different for me in that it was, 0 clients, right? Because it's only defense work. So I left all of those, a lot of them fantastic clients in very capable hands. But before I was able to do that, I needed to save a lot of money, bottom line, because I needed a lot of runway. I knew enough about personal injury on the plaintiff side to know that it's not from one day to the next. So I said, okay, I need about maybe 18 months or so of runway to, pay for whatever I need to pay for to get the firm going. And then obviously have, be able to, and like anybody else, pay rent, pay mortgage, car payments, school, all the things, don't just magically go away because I have this feeling and I want to do this thing. So that took about about a little over a year, to put the resources together where I felt comfortable doing it. Where I said, okay, I'm going to give myself a real shot at this, as opposed to just, hey, I'm leaving the firm, I'm going to give it a shot, and if it doesn't work, I go work somewhere else. That was not that wasn't I didn't have a plan B. Put it that way. I mean, everyone, as a lawyer, yeah, I can get a job somewhere else, but I didn't have a plan B, so I needed to make it work. And in order to make it work, I need to have the resources. So that's kind of the back part of it. The front part of it is I had been as a referring attorney to a couple of cases that were I didn't have any sort of a business or ethical conflict, and I I spoke to some of the clients at the very end after the case had resolved a little bit, just to kind of get an idea. You depose plaintiffs and you mediate with the plaintiff there, and you maybe try a case, and you cross-examine the plaintiff or what have you, but it's not the same as when you see the positive outcome
Mhm.
with everyone's guard down, if you will, as you do with that attorney-client relationship. And I saw truly the difference it made. In one of the cases, it wasn't that significant, but the other one was pretty significant. And you saw the real change in that person's life, and the okay, I can now do this other thing that I really need to do for my family, for my, you know, whoever it was, and as that's really appealing. So that, I think, coupled with needing to do something different, were the two kind of pieces that ignited it in my mind.
Very good. And so you kind of decided that if I'm going to jump on this floating iceberg, I'm not going to have another plan. I'm going in, but I'm going
Yeah,
to get all my supplies ready. I don't have another little boat to get off of it. I'm going to live
right.
on this iceberg, whatever it is.
Yeah,
So it took you a while. You made a plan.
yeah,
And then the other thing that I caught there is that it's a big mind shift representing people versus the corporations.
yeah,
Whereas maybe for a corporation, the difference in the case is just a number on somebody's accounting spreadsheet.
yeah,
Whereas if it's for a person, and particularly an injured person, it's the rest of their life, whether it's the rehab, whatever needs to be done to get
mhm.
them by.
Correct. Yeah, no, it's entirely different, and there are some positives and some negatives. I would say the one very good thing that's come out of making this change so far into my career is that my reporting, if you will, from a defense lawyer perspective, is very good. And so I'm just kind of, it's been drilled into me, right? To report, to update, to report, to update. So I don't really have, I'm not going to say everyone's always happy all the time, but one thing you can't say about my practice is we don't keep you updated.
Mhm.
Whether with calls or pretty lengthy emails explaining what's going on. So that part of it has been a useful tool. But I will say, and this is kind of obvious, but it's important to state it. In the defense world, everyone you run into in terms of whether it's for the most part, unless it's a very green field adjuster, everyone kind of up the chain knows what the score is. Let's say understands the cost of doing business, understands, okay, it's going to cost me defense fees, it's going to cost me experts. It kind of There's a lot of, I don't want to say unspoken, but it's very easy to kind of get into the groove and explain to someone what the case is about, because we speak the same language, to put it plainly. When you're dealing with an injured person who's never been in a car accident or never had, a product explode in their child's face, or whatever it is, they don't understand, what does the word discovery mean, right? What does it mean that we're going to give them our information? Why would I do that? And so there's a lot of that. Uh, there's a lot of the mechanics of it. I've become much better now at explaining them, and to not to dumb it down, but to simplify it in a way that makes sense for someone who doesn't have 20 years of adjusting cases. So I think that part was, I knew it was going to be a challenge. I didn't realize sometimes how much of a challenge, and then being able to tailor that to the specific client, because some of them are, like a professional, and they've done insurance work for whatever reason. They get some of the parlance, but then someone who has none, it's a different educational process.
And what did you perceive, if anything, that your background on the defense side maybe gave you a little bit of an advantage when you switch sides? Anything that you can think of?
I think I think a couple of things. I think it gave clients a measure, or gives them, I should say, a measure of credibility, because it's not something where, okay, well, I handled motor vehicle accident cases for 3 years at XYZ big firm, and now I'm now I know everything about the defense world. You know what I mean? So that's not as much as experience as some people may think it is sometimes. For me, I think the advantage is having dealt with, some of the most upper echelon of claims executives at different levels in different insurance companies, gives me a very good read on situations where I can probably see more than most lawyers who've only done insurance defense for a few years. So I think that's the big advantage it gives me, and I can kind of cut through a lot of it and see if they really need a document because they're considering a real offer, or they're just stringing me along. In which case, we're filing suit, and I'll deal with, a defense lawyer and go from there.
Yeah. So experience helps you to cut through the tape, so to speak.
Yeah.
So now that you've sat on both sides of the table, defense and plaintiff,
Yeah.
how has that shaped the way you approach negotiations today?
I think it's made it a lot easier in a way, because the values that I had on cases as a defense lawyer haven't really changed that much as on the plaintiff side. So whatever I used to kind of compute that, I use the same methodology here. And so when it comes to negotiating, um, I'm not really surprised too much by what carriers do, um, unless it's some wild card person but that's typically not the case when it comes to carriers. So I think that's what's helped kind of improve my approach, is understanding what each side fears. On the defense side, we would always say, well, if it's a solo practitioner or a smaller firm, we can push them, and you can push them to spend money and push them to expend, to use up resources, so on and so forth, to get to a better resolution if you can. That was always one of the strategies, right? Versus a bigger plaintiff's firm. So in my mind, now that when I'm negotiating a case, and I'm the solo or the smaller boutique firm, I'm well aware of the resources that I need to allocate, and when I need to allocate them, in order to make sure that the carrier understands that I'm serious about a case, which is, from my perspective, always the most effective negotiating tool, is the other side knowing you're serious about it, which means they know you've doled out $20,000, $30,000, $40,000 on experts or investigators or what have you. Okay, he's serious about it, so we really need to consider this is going to trial, or this is not just going to go away after we, meaning the defense attorney, spends $20,000 in fees.
Very good. And you mentioned earlier you have your methodology for calculating a case. Are you able to share that, or is that proprietary?
Uh, it's mostly proprietary, not because I think, well, it's proprietary to some extent because I don't think I'm the only person who uses the same thinking. But I will say that, well, number one, the idea of, 3 times the meds, right, is it reflexive? Yes. But I kind of tossed it out, and I was tossing it a little bit towards the end of my time as a defense lawyer. And now I don't really even think about that at all. For me, it's more, I think about, the story, and I what I always want to hear from clients is, I need to hear something more than anecdotal, something that's impacted you today that you can't do. Not, oh, I can't, let me say it differently. And I'll give you an example. Okay, I have a client who has some vocal cord paralysis, and it's pretty significant. Young guy, he's in his late 20s. I'll leave out the details of the case, but the important part is, always very social guy. Everybody used to come over to his place to hang out, pregame, all that fun stuff. Now, if he's at a friend's house or whatever, now he's much more withdrawn, much more of an introvert. But now, if he's out with friends or talking to people and there's music playing or something, he has to ask them to turn it down so that they can just hear what he's saying, which, as you can imagine, is pretty embarrassing, and it diminishes you, right? So those are the stories I look for with clients. Is what's that thing that's happening because of this injury that's really, really screwing with you? Not just physically that you can't do the thing, but how is that impacting you mentally? And that's just kind of one example of, wow, if you think you're at a house party or some friends are playing music, you have to ask them to turn it down, so that they can hear you. That sucks, right? So that, to me, and so there's a way that I formulate that, but those are the things that I look for. because those are the things that can resonate, no pun intended, with everybody, either with an adjuster or a claims person if they're like a higher up claims person if they're savvy enough, and certainly with 6 people or 12, depending on where we're trying the case.
And that's what you just said at the end with the jury is probably the most unsettling because how do you actually measure that? And that uncertainty is what the crux of a trial is, and that's what scares everybody. It could be
Yep.
big, it could be little.
You don't
We
know.
don't know. So you touched upon it a little bit, but in cases like yours, where maybe there's a catastrophic injury or even worse, a wrongful death, these are some of the most emotionally charged negotiations. So, how do you manage that emotion at the mediation table when that exists?
Um, I think early and often and well before we get to mediation. And in two ways, really three, if I kind of think it through all the way. One, the client, right, needs to understand, especially the client or the client's family, whoever's coming with them. And often, I mean, you've seen now post COVID, most of it is Zoom, but on a lot of these, like larger cases, I sometimes will insist on in person, because I miss that gravitas, let's say, that that real, I don't know, maybe because that's just how, and similar to yours, like we all grew up mediating cases in person, and it was just a different vibe. And not that almost all cases get done anyway, whether it's Zoom or not, but for me, I still feel if it's a very big case, I want to be in person. um Also for everyone's focus, I think it helps. um and then with the client, going back to that, I need to explain to them that they're going to hear things that are going to be unsettling, upsetting, may make them very angry, and they just need to hold on long enough. Not that they need to pay the closest attention to what's being said, especially if it's upsetting them, but just long enough to where the mediator can come in, obviously when we're caucusing, and help me turn some of that temperature down. That's kind of part one. Part two is, and this I try and do with every single case, whether it's a small fender bender that I'm helping someone out with, or it's a more kind of mainstream catastrophic case, I try and develop the best possible relationship I can with defense counsel.
Yeah.
As mean as, and if I can meet you for coffee, let's do it. Especially on a big case that I know we're going to be around each other for a while, conceivably. Let's do that, so that when we run into little skirmishes, that's just what they stay. They stay skirmishes, and they stay, I think I'm entitled to these documents for this reason. You disagree for that reason. We both understand our respective positions. Let's have the judge decide it. And one of us will be a little bit unhappy, and so be it. But that's number two, is taking me and my personality and defense counsel's personality completely out of the equation. So we're both approaching it as objectively in some respects as possible, understanding that I'm going to do my job at mediation and they're going to do theirs, and I may come off as aggressive because that's what's happened to my client, but he and I, or she and I, need to have as good of a possible relationship as we can. And the last one is with the mediator. If it's whether I've mediated with them before or I haven't, I try and set up a call. Obviously with mediators, and you'll know it better than I would, is you've got tons of mediations happening. So I don't like to have a call with them a week before, because you're going to have 20 mediations between that call and our mediation. I try and set it up maybe a day. The day of is too short, but the day before is fantastic. 2 days before is okay, and have a real conversation about the case, so that when I'm going through medicals or liability or whatever it is, it's not the first time they're hearing it, and you're already predisposed you already have some questions in your mind as you're ruminating over it, getting ready, so that maybe I'm answering some of them in the opening, maybe I'm not, or whatever the case is, and then it makes it easier, I think, for me to have to receive constructive feedback, because this is the second time the mediator's heard my shtick, if you will. And so now, okay, show me where the holes are, because if I'm missing something, it's going to be easier for you to spot it, let's say, the second time around, than just hearing it for the first time.
Yeah. Very smart. I like exactly what you do with opposing counsel in terms of not burning bridges, because at the end of the day, the case is both of your problem, right?
Yes.
And it's going to take two of you to solve it. And you can either do it together
Right.
through a settlement, or like you said, No hard feelings. We'll let the judge decide.
Right.
But most likely you're going to see each other down the road.
Yeah.
So let's be collegial about it. Um, in terms of the clients and emotions, what what impact have you seen if a client starts getting emotional? Do you think it impacts their decision making?
Um, it can, if not managed properly, especially if they're angry. And that's why, and that kind of goes back to the defense counsel relationship part is do your job, say what you have to say, but there are ways of saying things. And if you're going to piss off my client, that's not going to help you close this case. That's just the bottom line. If my client feels you're doing, your best for your client, and there are ways to do it, right? Then they'll respect your effort, so to speak. They'll understand that you're not on their side, but they have the the clarity, let's say, to make the right decision or at least get the right advice and then accept it and act on it.
Yeah, there's definitely well, I suppose you would not be in favor of relitigating your case during mediation.
No. I think mediation is the time for two things. I think when it comes to liability, it's streamlining it. Whatever your position is on it, you streamline that. And if there's certain deposition, moments that you want to clip out and show, sure, if it's really, really impactful. But one thing I've learned from mediating so many cases on the defense side is um, the defense lawyer is just there. You're just there. You're hearing it because you have to, and that's fine. But you really shouldn't be surprised by anything you're hearing, and neither should the adjuster. A tip to all the defense lawyers watching the program who are younger: the adjuster should never be surprised by anything they hear at mediation, because that's just bad news for you. That tangent aside, um, I think that you streamline that, and then that is your time though to really dive into damages, because the adjuster's just gotten a breakdown of your meds and whatever the injuries are, but that's and maybe some photographs, but this is your time to really explain what the surgery involved, what the recovery was like, those sorts of things. That's what mediation I think is for, more for the plaintiff lawyer, is to streamline liability and get the damages, because they've seen that in black and white, but they haven't seen it in color, if that makes sense.
Yep. Storytelling for sure.
Yeah.
So this is a favorite topic that we probably have observed at our former firm.
Okay.
Um,
Go for it.
Bad faith insurance claims.
hmm
For listeners who might not know, what does that mean? And then in the context of negotiation, how do you leverage that?
I think you have to be careful, because and I've got one that popped into my mind now where two defendants each has $1 million policy, but it did, given who they are, I'm like, this doesn't make any sense for this particular entity to have $1 million. That doesn't make any sense. So maybe 6 months into the case, we're now about 6-7 months. Magically, the umbrella policy appears, and maybe we're about a few weeks before mediation. And leveraging that the right way is, I think, the following. You can make the demand for the underlying plus the umbrella, but if the underlying is, again, I'll answer your question in a moment, but I want to just set up the example. If the underlying is 1 and the umbrella, let's say, is 10, and your case was always only worth 750, let's say, if you make the demand for 11, that's fine. But the 10's not taking you seriously anyway, right? So because they know there's not that exposure. So in those circumstances, I think the way to leverage, like, at least this particular type of case, is you go into the umbrella, but far enough where they feel it's they can, I guess, create enough hay to bang on the underlying, as opposed to just, okay, this guy's not serious, this case isn't worth $11 million, whatever. Underlying, you're clearly right, because the last thing you want to do is for underlying and umbrella to agree with each other. That's the last thing you want, because if they
On
agree with
your
each other,
side,
right? So if they agree with each other on their side, okay, that this case is worth nothing or fraction of what he's claiming, then then underlying feels no pressure to settle for their limits because they don't agree with it, and Big Brother, if you will, is supporting them. So that's what you need to drive a wedge there, and the way to drive the wedge is to pick a number that's far enough into the umbrella where they notice, but low enough where they think, "Wow, we might be exposed to this amount." So that to me is the best way to leverage it, and I truly think that, except for a handful of plaintiffs firms that and there are a handful that do a fantastic job, that have been around for a long time, that understand how to use that. Unless you've done bad faith on the defense side and at the underlying and at the excess level, you don't really know the advantages you can have, and you don't know how easily you can screw that up.
Let's shift gears and talk about a moment that really defined how you think about this work. So every attorney has a case or moment that has changed the way they see their job. You earlier spoke about perhaps a little bit of yours, but what I'm looking for is perhaps a defining moment for you, something that fundamentally shifted your approach to negotiation or mediation.
So there was one time, and it was a case that I handled at our old firm, maybe 15 years ago or so. It was a long time ago. We ended up doing all of the mediating and a lot of the depositions out in San Francisco. That's where the plaintiff lives. She was a paraplegic after a very tragic accident in a swimming pool in Orlando, where she dove off the shallow end mistakenly, and well, that was the net result. Really, really, really sad case. And the reason I bring that one up is because in taking those depositions of the parents and of her, and just a lot of that stuff just really stays with me. Like, as that case, even though it's been, I don't know, probably be 2 decades soon, however long, it's just has stuck with me because of just the imprint it left. Maybe probably as a young lawyer, is the first time I'd seen something that tragic and been been that close to it. And I saw how and truly liability was a big problem for the plaintiff. Like, it was. They were claiming lighting, they were claiming some of the materials that were used in the pool. It wasn't a great liability argument, but it was enough, to put a scare into people. But at the same time, it was what it was. And how the mediator was able to soften some of those edges. And I think we made it into like 1 in the morning or something, or 2. It was very, very late. We started like 11, maybe 12 p.m. and then went a long, long time, because the plaintiff's lawyer wouldn't come off, as you would imagine, the stratospheric numbers. And the defense lawyers were, in my opinion at that time, and still today, rightfully, pretty adamant about liability, and that the damages were horrific, but you still have to prove that we did something wrong, any one of us or a combination of us. And at the end of the day, looking back at the number now, it wasn't, even then it wasn't, and certainly not today's world, not today's money. It wasn't a lot of money. It was a lot, as you can imagine, but not what you'd think for something like that for a 15-year-old girl, and from one day to the next she can't walk anymore. But it had a big impact on me because I saw that these lawyers, and we had been, not so much me, I was just one of the co-defendants, not even one of the chief ones, but I saw they were at each other's throats for most of the case, and which was kind of pointless, but so be it. Another lesson learned there. But seeing how, with a good mediator, was able to kind of cut through all that noise, get to a number that made sense, that helped this young lady out tremendously, but made sense as well. And I guess at the end of the day, what I saw for the first time was, even in a case that's as contentious, as emotionally charged, there can be a resolution, even when it seems completely impossible. You can reach one, and that gave me a lot of confidence in the system going forward.
And what do you think the mediator did that was the most important and effective in that specific case?
I think he was incredibly patient with everyone, because it took a long time and I don't know, obviously I have no idea what was happening in the plaintiff's room, but it clearly took a long time to get, because, I mean, think of it, right? The parents need to blame someone, and not just my child made a terrible mistake that she's now paying for the next 60 years or 70 years, depending on time span, right, lifespan, and the unimaginable calamity it was for them. So it's like in anyone else, right? It's easier to, you feel better to some degree when you can blame, this person did this to me. And so that's why this thing is happening now, especially in these darkest moments for them. So I think it took a while for the mediator to get them there, which just required a lot of patience because they needed to kind of come around on a lot of issues emotionally. And at the same time, patience with the defense lawyers who needed to convince the adjusters, hey, look, you really need to fork over this amount, every one of you, to make it happen. Even if you don't feel that's going to be your share of responsibility, we need you to do a little bit more because it's still, it's eliminating that risk and getting them to come around because the liability was so challenging. So I think patience, in a word, is what it was the calling card of the day.
Excellent. I love that. Well, let's get into some practical tools that you rely upon. This is what I call the mediation toolbox.
So I'm gonna flip it on you right now.
Oh, okay.
And then I'm happy to answer the questions, but I want to see what you have to say about this.
All right,
So
go for it.
One of the tools, and you've probably used it any number of times, that mediators use, and it can be helpful, is the famous bracket, right? And it helps to cut to the chase and see where people are. I have no problem receiving a bracket, but it is, well, I'm going to grow a full head of hair more easily than I will providing a bracket number. I'm not that it's never happened or that it will never happen, but I don't like it, and here's why. And I'm curious as to your response. I feel that if I give a bracket, let's say the bracket's 100, 300,000, right? Just whatever it is, and the or better, a million, 3 million, and the
Before you go on, let me explain to our listeners what a bracket may be.
Okay.
So a bracket is where one side is proposing to the other if they come in between a certain range. In other words, Mr. Plaintiff, if you come down to $500,000, we will, in our offer, go up to $100,000. So in other words, trying to narrow the range of possibilities of where you might settle. That's a bracket. But now continue on with your example, Emanuel.
So using those same numbers, the problem I have with that, if I'm proposing it, is that I feel that if I'm proposing the 500 to 100,000, right, that there's at least the possibility exists that I'm willing to settle the case at that low end of the bracket, no matter how much chest pumping I can do and say, listen, don't think about that low number, just think about the high number. Right, the low number is there for a reason. So I think that you're selling some level of comfort to the other side that you're willing to play within that lower end of the space. So what are your thoughts on that?
Well, I'm not sure if I look at it differently or not than other mediators, but the way I see brackets are I call them the hypothetical sandbox. So in other words, the parties are going to create the four corners of this sandbox, and the range is this range. Do you, both of you, want to get in there and play around and see what happens in that sandbox?
Mm-hmm.
We don't know what number it will be, but that's the range. And ultimately, I see brackets as a messaging tool. Like, this is kind of where we are thinking of being. No higher than that, maybe no lower than this. A lot of times I find, at least from the defense side, they're always looking at the midpoints. I tend to always not suggest that. Maybe the parties do instinctually go there, right? And most likely they do. But for me, a true bracket is it's somewhere in there. It's not necessarily at the top end. It's not necessarily at the low end. It's somewhere in between. Do you want to get there? It's a call to Jesus moment. Often it's something that may be used towards the end where people are just butting their heads.
Yeah.
And they're still so far apart and we don't know who's bluffing and who's not. Well, this is a call to moment are you willing to go here? And if you're not, then we're never going to get anywhere today. So that's kind of the experience I have with brackets.
And I don't disagree with that perspective. I just feel that when you give a bracket, that at least, let me say it this way, and maybe this is more just me projecting that because of how I see brackets. When I receive a bracket, and so then I'm automatically looking at, as a plaintiff's lawyer, I'm looking at the high number and think, okay, well, you're clearly willing to play here or above there, because otherwise, why are you giving me this number? What, in other words, why are you not tempting me, but why are you hinting at it at this number? Again, it may be still very low compared to how I see the case or not, but that's my fear, apprehension in giving out a bracket. But to your point about, the kind of call to Jesus moment, that's why I like the mediator's number. That's probably my favorite tool that mediators use. Is okay. So obviously, if I reject it, they don't know, and that whole piece of it. But I like that. I like that the best, because now I know I'm hearing from a mediator who's heard both sides of the case, who has no dog in the fight, if you will, other than getting it done if he or she can do it. That's what that's my favorite tool that I see mediators use, is that one.
And is this one in which the mediator, at least in your experience,
Yeah.
has done it on their own, or you've asked for it?
No, both. Sometimes they'll say, look, I'm going to give you one. You don't have to, do you got, or better put, it'll be offered. Do you want one? And I always say yes, because what do I care? If it's a great number, then let's do it. And if it's not, then I won't. But the reason though I like them so much is because it's all because it leads up to that, right? I've done my homework with the mediator. I've sent them the statement or whatever documents I think that are most important. We've had the call. We've talked about it. You're sick of me now because you've heard so much about my case that you think it's the only case in the world. But so now I know when you give me that number, I know that you're not just mailing it in here. It's going to be $750. Like, I know you've had the opportunity to give it some real thought. And if I've done my homework better than the other side, you're probably giving me a better number. Not better because you like me, but better because you know my side better.
Now, it is not without controversy. Not sure if you're aware.
Yeah.
The ABA section for dispute resolution.
Yeah.
They recently released an opinion, an ethics opinion, on mediator proposals.
Okay.
And they were not real big fans of it.
Why?
The idea is that, at least the idea that they're bringing out, is that it is bordering into evaluation, which is not mediation, believe it or not.
Okay.
And that it can be somewhat, the whole idea of having your own responsibility for your case, your own free will, that the mediator, by giving a proposal, may be interjecting himself into your dispute.
Okay.
And that pressure in itself could be coercive to one or both of the parties.
Sure.
So there's this view that it's like a danger zone. Now, again, that's just one view, but it's one that's been talked about for the last couple months now a lot, where people are trying to figure out, well, what do we do with this given that opinion? I don't see it changing much on the practical ground right now, but it does give some thought.
Yeah. No, you're right. And because, I mean, in that, what I like about it is kind of what the ABA is concerned about. Meaning, the way that I framed it is, I want you to tell the other side essentially that I'm right. Right. with a specific number.
You just made their point, Emanuel.
Right. No, I know I did. That's fine. It's okay. You're welcome. Maybe they'll give me a free membership for the year or something. But no, I understand the concern. It makes sense. And I think the way to maybe quell some of that concern, it's not a perfect solution for the problem the ABA sees, not that I necessarily would agree, but I understand where they're coming from, is if the two lawyers in the case, or three or four, whoever, all are in agreement separately, nothing to do with you, Patrick, the mediator, saying, look, why don't we all get a mediator's number that will help us resolve the case with some additional information? no different than an additional deposition or a medical record or whatever. And that way, when we go to you, say, okay, Patrick, we have decided that we would like a mediator's number from you in order for us to represent our clients better. I think that maybe takes some of the edge off the concern, which I get where they're coming from, but I think it might take some of the edge off that problem.
Okay, fair enough. So back to, did I answer your question?
Yes, that that brackets are good and they are helpful, even if I don't like them.
All right. So now, in terms of the mediation toolbox, these would be like, say, some specific techniques that you rely upon for mediation. What are some of those that you would say are the most significant for the purposes of mediation?
I'm a big fan of the inter caucus negotiation sidebar with opposing counsel. I really like that with the mediator, sometimes without, depending on the circumstance. I'm a big fan of that because it helps to center things again, especially if they're kind of if and again, this is all, a lot of it though is based on having a good relationship with opposing counsel, because that lends itself more to not minding seeing each other in the same room or in the same, the same Zoom breakout or whatever. But I think that those are helpful to kind of recenter things, especially if you have, if you have a good understanding of what either side is, but don't quite see why you're still stuck at whatever number, or there's a particular issue that continues to be brought up. I think that's a very useful tool that a lot of lawyers don't use, because they get stuck in the 50,000, a million 50, 75,000, 833,000. They get stuck in that. And I think sometimes just a brief sidebar with opposing counsel saying, look, here's why we're pushing this issue, or here's why this continues to come up, whatever. And then you try and come to some accord on whatever that dispute is, which I think over time, if you do that at the right time, at the right moments, it can really begin to bridge that gap. Yeah, I think it begin to bridge the gap in a way that just simply passing numbers back and forth doesn't.
Well, communication and information matters, right?
Yeah.
That's what those sidebars are about, the exchanging of information.
Yeah. Especially in kind of on that same point is, if the reason there's a gap is because the adjuster or maybe I feel that there's a particular deposition that's so critical, maybe I can explain to the defense lawyer, like, here's why I don't think that deposition really is going to matter, because, Jimmy said this, Sally said that, and the cameras clearly show the other thing. And they go, yeah, I know, I got to talk to the adjuster and explain to her, because she or he might be kind of, and they get this way a lot of times, the judges, they get fixated on something. And this is another quick free tip to defense lawyers, the younger ones out there. Careful what you say in those reports, because, and that the language, man, is so important, because they can just get stuck on something. And that little,
talking about your adjuster.
Yeah, your adjuster will just get stuck on one phrase you used, one word. And they're kind of clipping that and taking it to the bank and holding the reserves low because of that one thing you said like a year and a half ago. So anyway, that's critical. But that's also, I think, part of the plaintiff's job at the beginning, because since we know so much more about the case than the defense lawyer does, the first time they see it, it's incumbent on the plaintiff's lawyer to provide as much information as you possibly can. Honestly, good, bad, or ugly, I don't really care, because it's going to come out anyway. So I'd rather control the messaging now and dilute that impact, or package it the right way, than not disclose it. And then it comes out, and then that's the thing that the defense lawyer is hanging his hat on. And then, everybody using it as a coat rack, and away we go. Yeah. So anyway, so that's, so communication, information, agree with you, are critical.
And what's your read on a mediator's role? Do you want a mediator who pushes hard, or one who stays out of the way?
Pushes hard, for sure, because as long as it's even-handed, right? Which you would hope, but isn't. I've had the experience where I felt that I've been more so on the defense side, but I felt that the mediator was just kind of really coming at us for no reason, which is fine if I feel and I can see based on the movement that you're doing the same thing to the plaintiff. But assuming that's the case, I'd rather get pushed because for two reasons. One, I need my client to understand that there is a real opponent on the other side. It's not just like, yeah, you've been deposed, but there's a whole faction of people that are fighting to keep you from getting money, right? Whether you like it or don't. So I think that the mediator being more aggressive helps to bring that message home. And two, I want to know, is there something I'm not fully considering and that the mediator is really harping on? And then I'm like, well, maybe we just ultimately see it differently, and that's fine too. But maybe I'm like, you know what, I should consider that a little bit more. And yeah, maybe the value changes, maybe not, you know what I mean? But I'd rather have that than someone who stays out of the way, because then what are we paying you for? You know what I mean? That's just my thinking of like, what was the point of all this? I could have just sat at a Starbucks and talked about it with the defense lawyer and tried to work it out.
Yeah. So with that in mind,
Yeah.
what do the best mediators that you've worked with do differently?
They cut to the chase on the critical issues, and they don't neglect those issues when the numbers start going back and forth. Now, you obviously, like you said earlier, you don't want to relitigate the entire case of mediation, right? And you most definitely don't want to relitigate the case during every offer counteroffer. But when there are important points to drive home throughout the number exchange, things that kind of still remain really important, like a witness statement or whatever, or a protocol or whatever it is, the best ones, in my opinion, don't let those things go just because we're talking about numbers. Now, obviously, when you're within spitting distance, you need to let that stuff go. Everybody does. But as you're working your way towards that, I think the best ones, don't ignore those items, because those are the ones that are going to eventually drive the number up or down. And so if you just get me straight into numbers within half an hour, but I've got real problems with my case, and the other side's like, hey, did you tell them about this? Tell them about that. Well, let's just stick to numbers. Well, no, let's not do that, because this is what's going to drive my number up or down, or vice versa. So I think that's what the best ones do is they're clear-eyed about the issues, and they don't let the important pieces of those issues go just because we're getting into numbers. Like the last time you talk about the issue should not be during during openings. That should not be the last time.
Can't agree more. So I want to now close with your top 3 tips for our audience.
Okay.
This is the part of the show where I ask every guest basically the same question, and everyone gives a different answer, which is really interesting and cool. So if you could give our listeners, our lawyers, mediators, business professionals, 3 specific actionable tips to get better negotiation outcomes,
Yes.
what would they be?
Okay. Number 1 is why, this is just the way I see it. Why is my case terrible? That's always a question I ask myself when I'm going through any case. I'm like, why is my case suck? Like, do I have bad liability? Do I have bad damages? And I say that because if I'm clear-eyed about my value, I don't really care what anyone else thinks, because I've thought about it from the worst possible scenario. Like, what's really bad about my case? And I'm always viewing it from that perspective. So I think if you take that, I don't want to call it pessimistic, but a really hypercritical view of your case, I think that serves you well, in addressing the client and preparing them, right, for whatever the negotiation may look like. And it gives you a great amount of credibility with the mediator, and certainly with any similarly clear-eyed defense lawyer or plaintiff's lawyer. I think that's important. I think it's also important to highlight, to some degree, right? Or I maybe say it differently, to acknowledge, and this is in the same vein, the positives of the other person's case. So if someone's saying, hey, look, you really don't, your liability is kind of tough. And yeah, you know what? I understand what you're saying, that this witness said this, and I agree with you, that's going to be a strong point for you to make. But have you considered that it was actually 8:00 at night? So it's kind of dark and it's summertime. So the lighting wasn't fantastic. So yes, she did say she saw that, and that's going to work for you. But here's kind of how I see the other piece of that. So I think when you acknowledge the relative strengths of someone else's case, it doesn't diminish yours, because as long as you have a response to that and ways that are credible counters, it only, the person feels good because they feel they're being taken seriously, which if you want to negotiate with anybody and they don't feel you're respecting them or taking them seriously, good luck getting whatever it is you want, especially if they're the ones that are holding the money. Right? Number one. And number two, it gives you credibility as well, right? So if people feel good about dealing with you, then the odds of that purse string getting looser go up. And then three, don't be scared. Whatever your value on your case is, don't be scared. I think that's something that I learned as I got older as a defense lawyer, that if my value was my value, it didn't matter if I was talking to a frontline adjuster or the VP of claims or the director of the directors or whatever. That's still my value. You don't like it? That's fine. Tell me why I'm wrong. And in the same on the plaintiff side, where, okay, yeah, you have 500 lawyers at your defense firm. That's great. Not all 500 are litigating the case, right? So that's fine by me. This is still the value. So I think that's the last piece of it. If you've done your homework, just stick to it, because odds are you're right.
Yeah, we hope so.
Yeah.
Well, those are really outstanding. So let's wrap things up today. So, Emanuel, this has been genuinely a valuable conversation. Thank you for sharing your experience and your insights with our audience. Before I let you go, where can people find you and learn more about your work or reach out if they need your help?
Sure. Thank you so much, for having me, Patrick. It's been awesome. I really appreciated it. A lot of great questions, and it's helped me to get my positions out on some things, which a lot of podcasts don't really do that. So thank you for that. So I can be found at my website, www.galimidilaw.com, GALIMIDILAW.com. I do a lot of posting on Instagram. So you can see me at Galimidi_law. I'm there as well. And if you need any help, 786-442-2873.
Excellent. Well, thank you so much for being on. And for everybody listening, if this episode was valuable to you, please subscribe, leave us a review, and share it with a colleague. Until next time, take care.
Thank you.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.